experience out there dealing with clients daily on this topic. What are the key pitfalls? I would say for clients, it's a failure to check and ensure competence. This isn't the only pitfall, but the biggest bugbear is the competence point. Lots of clients just don't appreciate that they do need to keep that alive. It's not just a question of ticking a box and then having a preferred list of contractors. That has to be revisited. It has to be refreshed. If you do identify issues with your client, with your contractors, that needs to be opened up, discussed, and measures taken. If you're unable to assess competence properly, take advice. And the schedule to the approved code of practice is really substantial nowadays. I mean, it's not under old CDM. You've got a huge list at the back now in the schedule as to the issues, the types of issues you should be looking at. So really, there's no excuse now not to do that. But by far, that's where I see most clients falling down, is a failure to appreciate that they do need, and it's a very serious obligation, to check competence. Designer, again, design changes, that's quite often where the designers do appreciate nowadays that they have these obligations, but sometimes it gets lost in the mist if you find that designs are changing and then no one has gone back to revisit or refresh the CDM responsibilities there. So if you are making changes, make sure they're reassessed. The CDM Coordinator, I guess, comes back to my point about staying involved after the initial phase. It's not a question of just setting things up and walking off site. It's an ongoing obligation you have if you are a CDM coordinator in relation to the project, and that's where I see some of the gaps arising now. People aren't going to, CDM coordinators aren't attending meetings, they're not really engaging, given that one of their primary obligations is to pull people together and to make sure there's adequate communication and coordination. It's a pretty serious issue if you find your CDM coordinators not there doing that. And again, competence. Again, advise your client. Make sure your client knows about this issue about competence. Very important. Principal contractors. The main issue for principal contractors, undoubtedly, managing your subcontractors. And we see it time and time again where we've got principal contractors, we're acting for them. They are prosecuted alongside their contractors, even though it's one of their contractors' employees who has unfortunately suffered some ill effects as a result of a health and safety failing. The principal contractor could well be brought into that. And why is that, do you say? Well, because they also have the obligation to manage their contractors and to supervise their contractors, to monitor what they're doing. Now, that's not to say if you bring on a specialist contractor, you then have to stand over them, the full time that they're undertaking their work. But you do have to engage with them. You do have to make sure, and if you're doing site walkarounds, just making sure that there's nothing screamingly obvious to you and your experience that these chaps are doing that they shouldn't be doing. So assess the competence of your contractors, supervision and monitoring and audit what they're doing. Now, just to conclude, a couple of little developments I want to mention. One is the expansion of jurisdiction. I'm sure many of you are aware of it, but up until very recently we had a situation where we've got all these amazing wind farms going on offshore, and actually CDM regulations only applies up until the territorial water limits. We do a lot of work in the energy sector and oil and gas, and so we're very familiar with the territorial water limits. And beyond those territorial waters, it was basically the oil and gas regime that would kick in. So it was all issues about safety cases, not at all appropriate for a wind farm in the offshore. That's changed now. Pleased to say that the CDM regulations have now been extended in terms of their territorial reach, and you'll now find that CDM does kick in when you have an offshore wind farm, regardless of what stage it's at, if it goes beyond the territorial waters. To be honest, the industry, the renewable sector, have been on this for some period of time, and the vast majority of people are complying with CDM in any event, so this will not come as a shock, but it just means that box has been ticked now. It is the law, and you have to be aware of that. The other point to note as well is that we have this document just came out earlier this week, I think. The HSE have commissioned frontline consultants to conduct an evaluation of the construction, the CDM Regulations 2007. And the purpose of that is really just to see if it's actually ticking the boxes it was designed to tick when they were introduced in 2007. So, for example, the whole point, or certainly some of the issues for CDM in 2007 was really trying to simplify the process so people could understand what their obligations were. It was also trying to assist in terms of planning for works, taking away most of the sort of paper-based attitude that some people had in relation to CDM, and actually just getting people to focus on the planning of the work. And it was also just to encourage cooperation and communication. These were the key issues for 2007 regulations. That's why they were introduced. With a view to seeing if that has actually worked, This is just a pilot study. So what frontline consultants have done is they've taken a sample of, I think, 10 principal contractors, 10 CDM coordinators, 10 clients, and they've asked them certain questions. And I think on the back of that, what they've recommended is that this study be extended much wider than that to go out to the industry on a wider basis and just take soundings to see if CDM 2007 is actually doing what it says in the tin and what it was designed to do. There are lots of questions in here about costs as well. How much more expensive is it now under CDM 2007? I think at one point actually the authors say they're kind of surprised that there may have been a cost implication because really CDM 2007 was simply just enforcing what was already there. But from my experience, it did more than that in the sense that it absolutely crystallised what's there. So I wouldn't be surprised if there were some cost implications arising as a result of that, because some people I know weren't complying with it pre-2007. So I guess watch this space. Like I say, pilot study, just giving some initial views on 2007 regulations, but with a view to recommending a much wider survey to be undertaken. So if you're working in the industry, you may well hear more about that. You may in fact be approached to cooperate if this does move forward.